Prince Edward has spent over 2 decades waiting on a promise the palace made, and Charles quietly considered breaking. And sources suggest most coverage of this story has completely missed what was actually at stake.
There are all sorts of issues and circumstances there, but we've been subjected to massive intrusion and all the rest of it.
This is not just about a title. It is about a 24-year inheritance battle playing out behind closed doors, with King Charles on one side, Edward's legal team on the other, and a royal family genuinely stunned by how it finally ended. The 1999 promise. Here is what actually happened. In the days before Edward married Sophie Rhys-Jones on June 19, 1999, Prince Philip did something that surprised everyone, including Edward himself. He told his youngest son, privately and directly, that the Dukedom of Edinburgh would one day be his, not Prince Andrew's, not merged quietly into obscurity. Edward's. Buckingham Palace then made it official, announcing that once the title had reverted to the crown following the deaths of both his parents, Edward would be created Duke of Edinburgh. Now, that announcement sounds straightforward. It isn't, because what Philip set in motion that week wasn't just a title transfer. It was a 24-year clock, one that would tick through Elizabeth's reign, through Philip's death in April 2021, through Charles's accession in September 2022, and through years of palace positioning that sources suggest was anything but passive. And here's the detail most people completely missed at the time. Edward was 7th in line to the throne in 1999. By the time the clock ran out, he dropped to 14th. His standing had shifted, the family's calculus had shifted, and the man who now controlled whether that promise was honored was his older brother. The promise existed. The question was whether Charles considered himself bound by it. What happened next suggests he genuinely didn't, because sources say the Queen knew that too, and she moved to close that gap before she died. Elizabeth locks it in. But here is what most people don't understand about how the Queen operated in her final years. She was not naive about her eldest son's instincts. Sources suggest she had watched Charles closely enough, for long enough, to know that a verbal commitment made in 1999 was precisely the kind of thing that could be quietly reclassified as advisory once she was gone. So she didn't leave it at a promise. Sources say that in her final years, Elizabeth took a step that went considerably further than anything previously acknowledged, tying Bagshot Park directly to the Edinburgh title in a witnessed letter of intent. Not a legal instrument in the strict transactional sense, but something deliberately more durable than a conversation. A documented expression of intent, signed, witnessed, and specific enough that walking away from it would require a decision, not just an omission. Why does Bagshot Park matter here? Because a title without a seat is a name without a foundation. And Elizabeth, who had lived inside this institution longer than anyone alive, understood that distinction completely. The estate and the title weren't separate considerations in her mind. Sources suggest she viewed them as functionally inseparable, that granting one without the other was, effectively, a quiet act of diminishment dressed up as generosity. The letter of intent was, sources say, a deliberate firewall, written at a point when Elizabeth's health was visibly declining, and the question of succession was no longer theoretical. She reportedly moved with unusual precision, not with the pageantry of an official royal instrument, but with the quiet, considered weight of someone closing a gap they knew existed. Charles, upon accession, inherited every lever of royal estate management. Legally, he had options. He could review, restructure, delay. Sources suggest those options were being quietly considered, but Elizabeth's documented intent complicated that calculus in ways that couldn't simply be set aside. The letter didn't bind Charles the way statute binds a government, and placing something in the record, in this family, changes what silence costs, which raises the question nobody inside the palace wanted to answer out loud. If Charles formally granted the title in April 2023, exactly what was he actually granting, and what was he still quietly holding back? The title finally arrives, and that question, what Charles was actually granting in April 2023, turns out to be the most important one nobody publicly asked, because on the surface, it looked like a clean resolution. On March 10, 2023, Charles formally announced that Edward would receive the Dukedom of Edinburgh. 6 weeks later, at Edward's 59th birthday, the letters patent were issued. Done. Promise kept. Sources suggest the palace communications team framed it exactly that way, as closure, as tribute, as a king honoring his mother's wishes. But the title itself arrives without the estate attached. That is the part that got quietly buried beneath the ceremonial warmth. Now, the Duke of Edinburgh title carries no territorial landholdings. It generates no revenue. It is, in the most precise legal sense, a name. What makes it a working ducal seat, what gives it actual weight in the institutional architecture of the monarchy, is Bagshot Park, the residence, the infrastructure, the documented arrangement that makes the title mean something beyond a line in a letters patent. People inside the palace understood this distinction completely. The granting of the title, without simultaneously confirming the estate arrangement, was not an oversight. It was, at minimum, a gap. and gaps in this family's legal history are rarely accidental. Edward accepted the title. What choice did he have? Publicly refusing would have been operationally impossible. But his team immediately turned their attention to what had not been said, because what Charles conspicuously left unresolved in April 2023 was everything that actually made the promise worth keeping. Which raises the real question: what exactly had Edward invested in Bagshot Park, and what was genuinely at stake? What Bagshot Park actually costs now here is where the promise stopped being symbolic and started carrying a price tag. Because Edward did not simply move into Bagshot Park and start living like a duke, sources suggest what actually happened was considerably more complicated than that, and considerably more expensive. The 1998 lease arrangement, as documented, was structured around terms that would have seemed almost punitive if Bagshot Park had been in any condition worth fighting over. It wasn't. The estate was, by most accounts, genuinely derelict, a sprawling Grade 2 listed mansion in Surrey that had been allowed to deteriorate to the point where habitation was barely practical. The lease terms reflected that reality: $5,000 a year, fixed across a 50-year term. On paper, that sounds like a gift. What the paperwork didn't headline was the accompanying obligation to restore the property to a functional standard. That restoration cost ultimately reached $3 million in total. Of that figure, Edward personally invested approximately $1.36 million. Not palace funds, not Crown Estate money. His own capital, committed to a property he did not own outright, on the basis of a promise that had no binding legal instrument attached to it yet. And this is the mechanism that changes everything about what came after. Because when Charles granted the dukedom title in April 2023 without simultaneously confirming the estate arrangement, he was not just leaving a gap in a letter's patent, he was leaving unresolved the question of whether $1.36 million in personal expenditure, sunk into a Crown-adjacent property across 25 years, would ever be matched by any security of tenure. Edward had, deliberately and documentably, turned a near-derelict mansion into a functioning ducal seat. The receipts existed, the lease existed, the investment existed. That paper trail was not an accident. Sources close to the situation suggest Edward's team understood, even in 1998, that expenditure of this scale needed to be recorded precisely because verbal promises inside this family have a history of evaporating. So the real question now becomes this: did Charles understand what that documentation actually meant, legally, constitutionally, strategically, when he quietly began rethinking what modern royal estates should look like? That belief, and where it hardened into something operational, is where this gets genuinely dangerous for everyone involved. Charles's modernization belief. Now here is where Charles's thinking becomes the most important variable in this entire story. Because Charles did not approach kingship as a ceremonial continuation of what came before. He approached it as a mandate to modernize, to audit, to restructure. And that belief, genuinely held and consistently applied, is what quietly transformed a promised inheritance into an open question. The specific assumption driving Charles was this: that becoming king granted him not just ceremonial authority, but active administrative power over the Crown Estate's portfolio. The houses, the leases, the arrangements that had accumulated quietly across decades. Sources close to palace operations suggest that by late 2023, this had hardened from philosophical preference into something operational. Estate reviews were being commissioned. Lease terms that had sat untouched for years were being pulled and examined. The question being asked, internally, was whether arrangements made under a previous reign still served the institution. That sounds reasonable. It even sounds responsible, until you understand what it actually meant in practice. Because buried inside that portfolio of leases and arrangements was Bagshot Park, the 1998 deal, the $5,000 a year figure, the terms that, on paper, looked almost embarrassingly favorable to Edward. And sources suggest that when palace auditors reached that particular file sometime in 2024, the reaction was not neutral. Here is the critical point. Charles did not necessarily frame this as targeting Edward. That is what makes it genuinely dangerous. A belief in modernization as a universal principle gives you complete deniability when that principle happens to land on your brother's front door. Nothing deliberate, nothing personal, just a king doing what kings do. But Edward's paper trail did not care about intentions. The documented investment, the witnessed letter of intent, the lease itself, these were not informal understandings. They were precisely recorded commitments. So when the modernization agenda quietly reached Bagshot's file, it did not find a soft target. It found a legal structure that had been built, sources suggest, to survive exactly this kind of review. The question is whether Charles understood that before the pressure started, or only after. Because the pressure did start, and Bagshot Park was directly in its path. Bagshot becomes a target. In late 2024, the estate review process that had been quietly expanding under the Crown Estate Audit Framework reached a specific, consequential point. Bagshot Park was formally flagged for reassessment. Not quietly shelved, not deferred, flagged. That distinction matters enormously inside palace administration because flagging triggers a formal review timeline, and a formal review timeline creates legal exposure for whoever is sitting on that lease. And who was sitting on that lease was Edward. The form the pressure took was, sources suggest, deliberately procedural, not a confrontation, not a direct demand. A series of written inquiries routed through palace legal channels, asking Edward's household to document the current use of the property, its maintenance status, and the basis on which the existing lease terms remained operative. Each inquiry, individually, sounds like routine estate management. Collectively, they were the functional architecture of a challenge. Why Bagshot specifically? Because stripping the estate from the Edinburgh title didn't require revoking the title. It only required letting the lease question remain open long enough to sever the two things that were always meant to travel together. A dukedom without a seat is a name on paper. It carries no household, no operational base, no physical presence in the landscape of the working monarchy. The people applying this pressure understood that completely. This is where history genuinely reframes the present. Edward had invested in Bagshot precisely because the estate and the title were presented to him as a package, not sequentially but inseparably. The 1999 promise, the lease structure that followed, the witnessed letter Elizabeth signed in her final years, all of it was constructed on the assumption that one validated the other. Remove the estate, and you don't just take a house, you retroactively hollow out everything that came before it. Now here is what gave the pressure genuine leverage: the lease's unusual terms. A 50-year agreement at £5,000 annually is not a commercial arrangement, it is a documented royal commitment, sources say, are precisely what palace legal teams know how to quietly reclassify when the political will exists to do so. Edward's household faced a narrow set of realistic options: engage and risk the review process, finding procedural grounds to reopen the lease, refuse and hand the palace a pretext, or surface the complete documentary record first before the review could frame the terms of the debate. Sources suggest Edward's team made a decision, and it wasn't passive. But here's what nobody on the other side of that review had apparently stopped to consider. Edward had kept everything. Every invoice, every witness document, every date-stamped commitment. The question now was whether that paper trail was enough to stop what had already started. Edward kept every receipt now. Edward's legal team didn't arrive at a meeting with a summary document and a polite request. Sources suggest they arrived with the complete archive, and that distinction matters enormously. The witnessed letter of intent from the Queen's final years, the original 1998 lease terms, the itemized expenditure records totaling over £1 million of Edward's personal capital, the date-stamped correspondence connecting the Bagshot tenancy directly to the Edinburgh title, all of it was assembled and presented as a single, coherent, sequentially documented case, not an argument, a record. And here's what makes that genuinely significant. Palace reviews of royal arrangements typically succeed by exploiting fragmentation. Find the gap between the verbal commitment and the paper trail. Find the lease clause that technically permits reclassification. Find the moment where intent was never formally witnessed. That's how documented royal commitments get quietly reclassified. As the previous chapter established, the process depends on the other party not having closed those gaps. Edward had closed every single one. The expenditure record alone was, sources suggest, the kind of documentation that reframes the entire legal character of the arrangement. This wasn't a grace and favor situation, a tenant occupying a property at the Crown's pleasure. 27 years of capital investment, repair costs, and documented improvements transformed the relationship between Edward and Bagshot Park into something categorically different. You don't sink that kind of money into a property on a ceremonial lease and then watch it get quietly reassigned, not without the paper trail becoming a problem. But the witnessed letter of intent is where the case actually hinged, because that document didn't just record a preference, it tied the estate and the title together as a deliberate, witnessed act, precisely the kind of formal intent that carries constitutional weight when someone tries to separate them after the fact. Charles's review team, sources suggest, had been operating on the assumption that the promise was essentially a soft commitment, honorable perhaps, binding in a family sense certainly, but legally reviewable because it had never been codified with the kind of precision that withstands formal challenge. They were wrong, and the paper trail made that clear before any external ruling was required. So Edward's team had done something the palace apparently hadn't anticipated. They'd turned a sentimental inheritance into a documented legal position. The question of what Charles could and couldn't unilaterally revoke was no longer theoretical, which is exactly where the constitutional reality of the situation starts to bite. Because surfacing the paper trail is one thing, what determines whether it actually holds is an entirely different question, and that answer came in the form of a written ruling that nobody inside the palace had prepared for. What the law actually says. The core question the ruling addressed was precise. What can a sitting monarch unilaterally revoke? And what falls outside that reach entirely? Sources say the legal team examining the situation had to work through two distinct tracks. The first track concerned the title itself, peerages granted by letters patent, which under established constitutional principle cannot be rescinded by royal prerogative alone without parliamentary process. That much Charles's advisors already knew, but they had apparently calculated that the estate question was separable, that Bagshot Park's lease arrangement sat in a different legal category, that it could be reviewed without touching the title. That calculation was wrong. The second track, and the one that generated the March 25 ruling, concerned Elizabeth's documented letter of intent. The question wasn't whether a letter of intent constitutes a binding legal instrument in the conventional sense. The question was whether a witnessed, formally expressed declaration of intent by a monarch tied to a specific property and a specific title creates a legitimate expectation so thoroughly documented that any attempt to sever the two becomes legally actionable. Sources say the ruling found it does, not because the letter was a deed, but because it was witnessed, time-stamped, deliberately constructed, and never subsequently revoked while Elizabeth lived. That distinction matters enormously. Charles had not anticipated that the standard of proof required to override his mother's documented intent would be this high. He had assumed that his prerogative as king to manage crown estate arrangements gave him sufficient authority. The ruling said no. A king can restructure. A king can modernize. What a king cannot quietly do is revoke a benefit that a previous monarch had specifically and formally conferred, without triggering a legitimate expectation claim that the courts will take seriously. And here is the complication nobody wanted to say out loud. The ruling did not just apply to Bagshot Park, it applied to the principle, which meant that every similar arrangement, every lease and estate tied to a title by documented royal intent, was now subject to the same legal logic. Charles had challenged one arrangement. The ruling answered with a framework that covered dozens. Edward's team had not just defended one inheritance, they had accidentally established a precedent, which is why the palace's reaction to the March 25 ruling was not measured or strategic. The question now isn't what Charles does next. The question is, who else inside that family just quietly pulled out their own paperwork to see if the same logic applies to them? The palace stunned. The palace's reaction to the March 25 ruling was not measured. It was not strategic. Sources say it was, in the most precise word available, stunned. And that word matters. Because institutions like Buckingham Palace do not get stunned easily. They have communications teams, legal advisors, constitutional scholars on retainer. They wargame scenarios. They prepare contingencies. What they apparently did not prepare for was a ruling that landed with the force of settled principle rather than narrow case resolution. Sources suggest that at least 3 senior palace officials were caught genuinely flat-footed by the scope of the language, not by the outcome itself. Edward's case was always defensible, but by the framework the ruling constructed around it, a framework that nobody in that building had stress-tested against the full inventory of royal estate arrangements. Now here is what that means practically. The working family holds property under dozens of lease and tenure arrangements, many of them tied to titles and roles by letters, precedent, and royal intent that predates the current reign. Some of those arrangements were always assumed to be at the king's discretion. After March 25, that assumption is considerably shakier. Sources suggest that within 72 hours of the ruling, at least 2 other royal households had quietly instructed their own legal teams to review their positions. Think about what that means. Charles challenged one arrangement. He received a precedent that may protect arrangements he had not yet targeted, while simultaneously limiting his ability to revisit any of them. But here is the part that resets the power map completely. Edward, who spent the better part of 3 decades being treated as the peripheral royal, the one the institution could quietly deprioritize, has now become the royal whose legal team accidentally fortified the entire working family's property security. That is not nothing. That is leverage of a completely different order. The conversations happening inside the palace right now are not about Bagshot Park anymore. They are about what Edward's win means for the institution's broader architecture. One challenge produced one ruling. That ruling opened every door in the corridor. And the question nobody can answer yet is which door Edward decides to walk through next. What Edward actually won. So here is what Edward actually walked away with. Not just a title, not just a house, both confirmed, documented, and inseparable in the way that Elizabeth always intended them to be. The March 2026 ruling effectively closed a 24-year loop that two monarchs, one deathbed wish, and one very carefully assembled paper trail had all been quietly building toward. And the significance of that is genuinely hard to overstate. Because Edward spent the better part of 3 decades as the royal, the institution could afford to deprioritize the one who dropped from 7th to 14th in succession, the one whose dukedom was publicly described by Edward himself as a pipe dream, the one whose claim was considered optional, revisable, deniable. Framing was deliberate, a way of keeping the promise alive in public while preserving flexibility in private. But what the ruling actually confirmed is that flexibility had limits. Elizabeth's documented intent was not sentimental, it was structural, and Edward's legal team proved it. Now he holds the title, he holds the estate, and he holds a precedent that nobody inside the palace anticipated creating. What this signals about Edward standing inside the monarchy is something sources describe as a complete repositioning. A royal whose legal infrastructure is now more robust than several who outrank him in succession. The 24-year promise is closed, the denial is reversed, the stunned silence inside those palace corridors is real. But here is what nobody is saying out loud yet. Edward didn't just inherit what Charles denied him. He may have inherited something considerably larger, and the institution is only beginning to understand what that means. Edward holds what was promised in 1999. He won. Charles, who nearly buried that promise, lost the argument history made for him. The title carries no land, revenue, or real power. That's precisely the point. What does Edward plan to do with it? A symbolic crown on an empty throne?